Good afternoon and welcome to the Ray Law International Channel. I'm so glad that you could join us today. Blended families are a normal part of our culture and society. So inevitably, we will have to address blended families within the practice of immigration law. Thankfully, when the framers drafted our Immigration and Naturalization Act, they took into consideration that children from a prior relationship may need to be addressed. Weekly, we receive calls where we are bringing not just the spouse to the U.S., but the spouse's children. Let's dive in and find out whether your stepchild can get a green card. One of the most common ways for someone to receive a visa or a green card is through family. But what happens if your spouse has a child from a prior relationship? Now, you have inherited a new child, your stepchild. If you are a temporary worker, can you get a visa for that child? If you are a U.S. citizen or green card holder, can you get a green card for that stepchild? Can a U.S. citizen file for a step-parent? The answers will vary, yes for some and no for others. You may often hear or read the phrase immediate relative, and you may know that immediate relatives can petition for other family members. But what is an immediate relative? Immediate relatives are spouses, children, and parents of a U.S. citizen. Generally, stepchildren are considered children if they meet the definition of child. Stepchildren are considered children for immigration purposes if the marriage took place before the child's 18th birthday. Why 18? In the United States, a child is considered a minor until they turn 18. Minors fall under a different jurisdiction than adults. They have different legal protections and rights. They are tried differently in the court of law. They receive different social benefits, and they are prohibited from doing certain things, such as buying cigarettes or renting a car. Once the child turns 18, they inherit the rights of an adult and responsibility and liabilities as well of an adult, I might add. U.S. citizen stepchildren can also petition for their step-parent if the relationship was formed while the petitioner was a minor. In closing, remember that if the marriage took place prior to the child turning 18, that child is considered an immediate relative and thus can obtain a green card. Thanks again for joining us today. I hope you found this information helpful. If you did, share it with your friends and community. Thanks for watching, and check out our other topics that interest you. Bye for now.